Hello, everybody. Thank you so much for joining us today for episode 13, I believe, 13 of our Third Tuesday webinar series. My name is Janelle Stanton. I am the Vice President of Communications here at myHRcounsel and have been doing this Third Tuesday. We did it all through 2019, and we'll be continuing that forward through 2020 as well. And so I just want to again say thank you so much for joining and for all the great participation that we had from everybody last year. Couple of things. So we have an absolute ton to go through today because we are going over all of the Q1 for 2020 law changes in all 50 states. So when I originally thought up and dreamt up this presentation, I thought, oh, this will be great. As I put the materials together, I thought, oh my gosh, why did I ever decide to do this? But please hang in with me. I am going to go through all 50 states. It is a high-level overview. So if you have questions about the specific law, I probably am not going to have time to get really into the weeds on those questions. But if you are a client of ours, please feel free to send in a ticket to one of the attorneys. If you're curious about how to get signed up, you can let me know that too. And then questions that do roll in, if you've been in one of my presentations before, you know that I always do write a typed up Q&A that I distribute to all of the attendees after the fact. So if you have a pressing question, please feel free to put that in the questions box, but be gentle with me. I may not be able to get to those questions in the amount of time that we have here. So that's really all that we're going to be covering today. As always, this presentation is going to be recorded. We always will send out the recording, so if somebody else in your office needs to listen to it, you're going to have access to it. We also will be sending you the HRCI credit code. So for those of you that come in and stay in for the entire presentation, you will be eligible for 1 credit hour of HRCI credit. You'll get a survey that tells us how we're doing. It also gives you the opportunity as our listeners to be able to request various topics. So if there's a pressing topic that is of interest to you that you want us to present on, this is how we create these presentations. So please take the time to do that, and we always try to be very responsive and get you guys content that matters to you. So watch for that email. Again, this email will come to everybody. If you don't see it in today or tomorrow, it's likely for 2 reasons. 1, I'm still typing up your Q&A, and 2, these sometimes take a very long time to download. So don't fret if you don't get the email right away. It will be just around the corner for you. So, all right, I'm trying to get my auctioneer voice going here for you. So can I talk fast enough? I don't know. We will see. So fast pace, high level, here we go. All right, Alabama. So for Alabama, I've actually got 2 slides here, which sometimes always blows my mind. It totally depends on the state, of course. But for this is actually became effective back in September, but I didn't feel there was much pomp and circumstance surrounding the passage of this particular law. So for those of you that are in Alabama or have employees working there, as of September 1st, 2019, employers are prohibited from discriminating in pay due to race or sex. So Alabama basically created their own Equal Pay Act, and also it creates a cause of action so that if an individual chooses not to share their wage history, or if they choose to share their wage history, so if employees are discussing what they were paid with each other, or if they refuse to tell somebody their pay. So if they're in an interview and you ask them, hey, what was your pay history? And they refuse to say that, and then you don't hire them because of that non-disclosure, they actually are going to now have a cause of action that they can bring against a company for retaliation if they feel they've been retaliated against. Also, as of September 1st, 2019, it was a busy fall in Alabama. Employers may not refuse employment to an individual with a disability on the basis of his or her disability alone. So if somebody is suffering from a disability, that can't be the sole basis of refusing employment. There has to be, you have to, as the employer, be able to show that that person with a disability will not be able to perform the functions of the job. So that is going to be a new requirement in Alabama. And it also makes it illegal for a person to misrepresent an animal as a service animal. So we're all kind of familiar with this idea, right, that there may be some abuse of a service animal, designation. So people want to bring their pet on a plane and they don't want to put them underneath where the luggage goes. So they say, well, they're a service animal. Now in Alabama, as of that September 1st date, it is actually illegal to misrepresent an animal as a service animal. So in the employment context, if you have an employee trying to say, oh, I need this service animal, that misrepresentation is illegal. Alaska. Starting in January 1st, 2020, the minimum wage is increased across the board to $10.19 per hour. If you're in Alaska, make sure that your payroll processes are reflective of that new minimum wage. Arizona, and you guys are going to hear me, minimum wage is all over the place. And just so you know, too, we are going to be going fast. So if you're out there taking notes, you're going to get a copy of this deck as well. So you're going to be able to re-reference it. But there's a ton of minimum wage. And when you get to California, you're going to be absolutely mind blown by the number of changes. But Arizona's minimum wage will increase to $12 an hour as of January 1st. And then there's also this new, in Arizona, this professional license reciprocity. This was back in August of 2019, but again, I chose to highlight it here because it's another one of those, I think, laws that was passed that kind of didn't get very much attention. So if you're in Arizona, there are certain professional licenses from other states that employers will have to recognize in the state of Arizona. So if an individual has been licensed as, for example, nurse practitioner or something like that, there's certain professional qualifications, but you may need to recognize if they've had that license for at least 1 year in another state without disciplinary action, you may need to recognize that license for them to be employed in Arizona. So if you're in one of these professional or occupational categories, be aware that you might need to honor somebody's out-state professional license. Arkansas, minimum wage goes up to $10 an hour. Also in Arkansas, kind of interesting, but effective on January 1st, they made some changes to the top income tax withholding rate. So that's actually going to be decreasing along with the various number of income tax brackets. So for those of you that have employees in Arkansas and you're doing income tax withholding, know that those tax brackets have changed effective January 1st. Everybody wait for it. So I promised it already, but California is like six of the next slides here. They're always very busy passing employee-friendly laws out there, so they didn't disappoint for this first quarter either. I've got water and I've got coffee here to keep my voice going. So minimum wage increases, these are all effective 1/1/20. So across the state, for those of you that might have 26 or more employees, the statewide minimum wage is going up to $13 per hour. If you have 25 or less, it'll be $12 per hour. So again, that's 1/1, and that is statewide. Now comes all of the various cities. So Belmont, Cupertino, Daly, however you say that. You guys can tease me if you're from California. El Cerrito, Los Altos, Menlo Park. All of those are going to have new minimum wages as of 1/1/20. It continues. Mountain View, El Novato, they have a minimum wage, again, that is tied to the number of employees that you might have. Oakland, Palo Alto, Petaluma, again, 26-25 seems to be a very popular breakdown of what the minimum wage is going to be. Redwood City, Richmond, again, all of these effective 1/1/20. And like I said, I see kind of still people filtering in here. I will send out the slide deck, so don't feel like you fast and furious have to take down these numbers because you will get access to all of this. The city of San Diego, $13. South San Francisco, San Jose, San Mateo, Santa Clara, Sonoma, Sunnyvale. That's the end of it as far as the cities that have their own minimum wages, but by far it takes the cake over any other state in the country as far as having cities with unique minimum wage amounts. A couple of other things that California did. So there was a bill that was enacted that extended the statute of limitations for employees to file various types of claims, so discrimination, retaliation, or harassment claims at the DFEH. And so that is increasing from 1 to 3 years. So if you have terminated an employee and the employee feels that you terminated them for some type of discrimination like national origin discrimination or disability discrimination, previously they would have only had 1 year to bring that claim before the statute of limitations ran, and now they're going to have up to 3 years. So again, what you're going to, another sort of implication of that is you should also now in California increase the amount of time that you keep personnel records, because with that new 3-year statute of limitations, if somebody brings a discrimination, retaliation, or harassment claim, 3 days before the deadline, but you have been purging those files after 1 year based on the statute of limitations, you're now going to need to keep those for up to 3 years to make sure that you've got documentation to back up your valid non-discriminatory intent for the termination. So again, the longer time, but what that actually means for employers is make sure that you're keeping those documents longer. Now, this AB 51 has made employment arbitration agreements prohibited. So if you are an employer in California that was trying to require employees to arbitrate any disputes that might arise, those are now going to be prohibited by that new arbitration law. We have expanded lactation accommodation requirements for nursing mothers. So now employers are required to have a lactation policy, and you're required to provide a lactation room, and it has to meet all of these various requirements. And so please note, this is not going to be a bathroom or a stall in a bathroom. There's very specific requirements here. So employers that have 50 or fewer employees may be able to demonstrate that this imposes an undue hardship, and so they're exempt from these requirements. But note, if you are in California, you probably already know this, it can be very difficult to reach those burdens to show that it's an undue hardship. So just be aware that these requirements apply to all employers now, and it's just employers with 50 or fewer that can try to say they're exempt because of undue hardship, but it's pretty high bar to meet there. Hairstyle discrimination is again another one. So the Crown Act expands the definition of race to include traits associated with race. So now in California, because of this act, if somebody feels that they've been discriminated against on the basis of their hair texture, hairstyle, for example, dreadlocks, that is now a protected class, and so an employee may be able to bring a claim against an employer saying they've been discriminated against on the basis of their hair. Where this comes up a lot is companies that try to say you can't have, men and can't have long hair, or it needs to be of a certain appearance, and then companies that don't provide accommodations because of that can face race discrimination claims on the basis of that. This is a big one, so this one has gotten a lot of attention, but there's basically a new test for independent contractors from this Dynamex case in California, and what it does is it presumes, as of just a starting point, that all workers are employees. So you now, if you are using independent contractors within your workforce in California, you're going to have a much more difficult time actually proving that they are an independent contractor. The consequence of improperly classifying somebody as an independent contractor is you probably haven't been paying overtime. Maybe they're not getting minimum wage, and there's many other employee protections that they would have been entitled to that you now haven't been giving. So if you're in California, I urge you, if you use independent contractors to try to if you try to use that to, claim that they're an independent contractor, make sure you do that analysis. And I did just get an FYI here. So somebody typed in that the arbitration agreement from the last slide, 2 slides ago, is on hold. Thank you so much. So I will get back with a more definitive answer on the status of that in my typed up Q&A. But thank you for bringing that to my attention. This stuff changes constantly. So, okay, this is another big one, the California Consumer Privacy Act. So, again, this is probably could be its own presentation as well, but California has passed this new act that basically requires policies be put in place for companies that collect, share, or sell California consumer personal data. This applies to employers because often you're getting information about them like social security numbers and other protected health information for getting an employee enrolled in health coverage, as an example. So there's several new of these, there's several requirements that go along with this, more again than what I could possibly cover during this presentation, but know that that is out there in California. And there's also now a no rehire provision. So I see these a lot of times in settlement agreements where a company will say, and you agree that, we're terminating your employment, we're giving you this severance, and as part of that, you're going to sign off on this settlement agreement or separation agreement. And so what you're saying is that you can't now say we will not hire you again in the future, and you agree you won't apply, that sort of thing. There is some exceptions in that law, but for the most part, you're not. If it's just a termination for poor performance or things like that, using a no rehire provision is now illegal under that AB 749. Yes, we will be providing a copy of the presentation for you. So in Colorado, the minimum wage increased as of January 1st, so it's going to increase to $12 per hour. Denver's minimum wage is, of course, going to be higher because it's Denver, so it'll be $12.85 per hour. Starting December 19th, the Colorado Department of Labor has adopted a new rule saying that any unused vacation pay that is earned and determinable in accordance with the terms of an agreement, so it's if they have PTO that they've earned, it must be paid to an employee upon separation from employment. Use it or lose it policies in Colorado are no longer going to be allowed. So if you are a Colorado employer, make sure you're looking at your vacation or PTO policies to make sure that you're removing those use it or lose it language, and you're also making sure that you're now going to be setting up a way to make sure people are paid out for that vacation. So wage theft, this is becoming a new thing. Minnesota just got a wage theft law last year. Colorado, starting January 1st, 2020, employers who willfully, meaning purposefully, refuse to pay wages, they actually commit theft, which is going to be considered a felony. And so payment of less than minimum wage is regarded as theft as well. What's interesting about these laws is people are like, well, yeah, okay, well, I'm not committing, theft. I pay my employees, but there are other things that can be considered wage theft, like misclassifying employees as independent contractors, misclassifying employees as exempt when they really should be non-exempt. So it may not rise to the level of a felony, that you would end up having to go and potentially serve jail time for. But this wage theft law, it should open employers' eyes in Colorado to make sure that all of your pay practices, not just minimum wage and overtime, are legally compliant. All right, Connecticut. So Connecticut, this was again effective back October 1st, 2019, but I put this out there so people know this is on the horizon, that employers have to provide 2 hours of sexual harassment training to all employees no later than October 1st, 2020. This is again, I might have, yep, I got a duplicate. Sorry, never mind. That one's just a duplicate. Delaware, as of 12/28/19, there's now individuals are able to apply to have many more forms of criminal records expunged than what they were before. And so, most states, and this is a background check, presentation for another day, but if an individual has their records expunged, typically employers are not able to use those in making employment decisions. So if you're in Delaware, just know that there are expanded reasons why an employee will be able to get their criminal records expunged, and may limit what you can actually use those criminal charges for. So. All right, moving along, District of Columbia. This one I thought was really interesting. This isn't one that we really have seen across a broad spectrum. There is a requirement as of 1/1/20, if you're in DC, that employers who employ tipped employees, except for hotel workers, so restaurants and that sort of thing, you are now required to use a third-party payroll processor to do your payroll. And that was as of 1/1/20. There is no minimum threshold on that. So employers with even 3 or 4 employees, they're going to have to get a third-party payroll provider in DC. Also, we've got a minimum wage change up to $15 per hour. There's also some paid leave now in DC as well, that beginning on January 1st, 2020, employers are going to be responsible for posting and maintaining a notice that explains their right to use these paid leave benefits. They can't start using the leave until July 1st, but know that what was passed way long time ago in 2015, more components of this paid leave keep coming into place. And so as of January 1st, this is now where you have to be complying with those posting notice requirements. All right. Florida, we've got minimum wage increases to $8.56 per hour, $5.54 for tipped employees. Georgia, there's not a statewide, but we do have a new Atlanta ordinance that bans smoking and using vapor products in areas as of January 1st, 2020. Again, this is a response. There's already a smoking prohibition, but now this includes vaping products as well. Hawaii, actually, this is marijuana related, new law as of January 11th, 2020. Individuals who are caught with 3 grams or less of marijuana will no longer face jail time. They'll have a fine instead. But do note that if you are a fortunate human to have employees and yourself working in the state of Hawaii, it doesn't change the fact that in Hawaii, there's no employment protections for recreational users of marijuana in Hawaii. So there is no change to that, but there is becoming a higher level of acceptance, which could lead the Hawaii legislature to enact some type of employee protection, but they don't currently exist. Idaho, none. Illinois, we've got Illinois again has been one of our busier states. So there's a minimum wage increase, $9.25 per hour, $5.55 for tipped employees. Cook County's minimum wage is going up. There's also now, as of 1/1/20, you've got 1 year if you're in Illinois to conduct sexual harassment training. This needs to happen at least annually, And then those that are in the hospitality industry also have an additional requirement to provide an anti-sexual harassment policy within that employee's first week of employment. And if this isn't a policy that you have, this is absolutely something that we do create for our clients. So if you are a client, let us know if you need one of these. But get that training done by the end of 2020. Another big one, marijuana is a common thread throughout this presentation. So as of 1/1/20, Illinois has legalized recreational use of marijuana. Now, this doesn't mean that you necessarily need to allow somebody to use it or be under the influence of it in the workplace, but you may need to accommodate somebody who uses marijuana outside of working hours in Illinois now. And so if you do have an employee fail a drug test that indicates marijuana use, you need to do an analysis of whether you can actually use that test against that particular employee. The Human Rights Act now covers employers with 1 or more employees, so it used to be 15 or more. So what this does is it expands the number of employers who have to watch out for these protected classes to make sure that you're not discriminating against protected classes. So basically, all employers now in Illinois will need to be sure that they're not discriminating on the basis of race, gender, ethnicity, national origin, disability, all of those things. Again, effective 1/1/20. There's some new record-keeping requirements, so there's going to be some penalties for failure to maintain payroll records. Employers are already required to keep records, payroll records, but now there's going to be new requirements. So in Illinois, make sure you look at your payroll and your pay stubs to make sure that you're recording the number of hours worked by each employee on a daily and weekly basis. This is a big requirement, and there's no exception for salaried employees. So you do have to keep those records and keep them internally for both exempt and non-exempt employees, and that was effective as of 1/1/20 as well. So that's a new record-keeping requirement, and there's some new financial penalties along with that. For those of you that are in Chicago and that are in one of the industries I've listed here, so building services, healthcare, hotel, manufacturing, etc., there are some new Fair Work Week ordinances that you need to be aware of. You're going to be required to provide 10 days advance notice of work schedules. Now, you see here, it applies to employers with 100 or more global employees. So this is for those big chains that you can think of that, big hotels, big restaurants, that sort of thing. So there is a predictive scheduling requirement now in Chicago for people in those particular industries. Indiana had none. Iowa had none. Kansas had none. Kentucky had none. Louisiana had none. See, now we're making some good progress here. Maine has a minimum wage increase, so the new rate will be $12 per hour or $6 per hour for tipped employees. So again, some changes to minimum wage there. I have to grab some water here. Bear with me. All right, so we're about halfway. We're to all the ends here, so I think we're making some good time. Maryland has a couple of things here. So Maryland's minimum wage as of 1/1/20 increased to $11 per hour. That is a statewide increase. And then Montgomery County has enacted their own, has amended, their own anti-discrimination law to again include hair texture and protective hairstyles to the definition of race. So in that particular county, now certain hairstyles are going to be considered a protected class, such that if somebody, an employee, does feel they've been discriminated against on the basis of their hair, they would have an actionable claim to bring against the employer. One thing to note here, and this is sort of what happens when states start passing these. New York kind of got this ball rolling, but I will tell you that everybody sort of borrows from everybody else. So the more of these hairstyle discrimination laws that we see get passed, you can be pretty assured that if you're not currently in a jurisdiction that has that, you will probably eventually become in a jurisdiction that has it. It's definitely what has happened with salary history bans, increases, marked increases of minimum wage and things like that. So even if you're not in a jurisdiction that has a law, I still recommend that you not discriminate on the basis of hairstyle. Massachusetts has a new minimum wage, so it's going from $12 to $12.75. There's also what's called this blue law. So what this is, and this is kind of interesting. So as of January 1st, 2020, there's a premium pay rate for all hours worked on Sundays and certain holidays. That's going to be reduced. So this is going to continue to decrease every year by 0.01 until it ceases to exist. What Massachusetts had was anybody that was working in retail had to be paid a premium level of pay if they were required to work on Sundays and holidays. And now this is going to start going away. So it's kind of an interesting undoing of these laws. So here's a question about hair. This is very interesting. So what about hair color? Can they color their hair pink or blue or purple and be protected? So I'll just go back to that Montgomery County one there. So usually what these hairstyle laws are is they're related to texture or styles that are usually associated with race. So dreadlocks or afros, that type of hair style or texture. Now, if an employee colors their hair purple because of some type of religious reason, so they've got this sincerely held religious belief that their hair must be dyed purple for 2 weeks in April, whatever. There could be times when allowing an employee to color their hair might be considered a protected activity, such that to punish them or discipline them for it would be discrimination. However, it's not going to be under these discrimination laws of race. It might be under a religion, protected class. But if it's just, I like this color, it's pink, I want to have pink hair, and it doesn't comply with an otherwise neutral dress code, you can go ahead and tell them that and discipline them for not changing it unless there's some type of religious reason for it. So what if they're in a client-facing position? It doesn't matter, because if they have a valid religious exception for it, you're probably going to have to consider accommodating it. But every situation is different, so ask them, why do you have purple hair? You know that you're client-facing, you need to look professional. If they just say, well, just I like it, then you can say, well, I'm going to need you to change it, and that's fine. Michigan also has a minimum wage increase up to $9.65 per hour. If you're in Grand Rapids, as of December 1st, they did expand the types of employers that are covered by their Human Rights Act, and expanded the protected classes there. So if you're in Grand Rapids, just something to be aware of. Minnesota, so Minnesota's got some wage increases. The minimum wage for large employers is going to go up to $10 per hour. For small employers, it'll be $8.15. I already talked about wage theft with Colorado, but Minnesota already had a wage theft law, wage theft statute. Minneapolis got on board, and as of 1/1/20 has enacted their own wage theft ordinance that is even more strict than the statewide one. So if you are in the city of Minneapolis, there's some new record-keeping requirements that you're going to have to comply with that are different from the state wage theft law. Duluth, all the way up north where it's very, very cold, they've passed their own earned sick and safe time ordinance. So as of 1/1/20, employees in Duluth need to be able to accrue 1 hour of paid leave for every 50 hours worked. Employers can front load 40 hours, but if you are an employee or employer in Duluth or you're in Minnesota and have employees working there, something to be aware of. Mississippi has none. Missouri has a minimum wage increase to $9.45 per hour or $4.73 for tipped employees. So you're seeing this again too. Tipped employees are getting a big boost in many states for their minimum wage. Montana, their minimum wage is going up all the way from $8.50 to $8.65 per hour. Nebraska has none. Now this was interesting. So what we do here, for those of you that are not familiar, all of the attorneys here are responsible for pulling together these state law updates. And so what we do is we try to be very democratic about it, and we divide up the states, and everybody has to take these sort of heavy touch states. So we don't give one attorney Illinois, New York, and California because it would drive them insane. So we split these up and we say, okay, like for me, I did Arizona, DC, Iowa, I'm like, okay, well, DC will be big. I get Nevada thinking, oh, it's going to be a small, what are they doing out in Nevada? I'll take it. Nevada is becoming the New Jersey of the western side of the country. I mean, I was absolutely blown away by the number of laws that Nevada passed regarding employment law. Need a coffee drink there. So a couple of things that are very interesting, I think. So if you are in Nevada as of January 1st, employers are prohibited from refusing to hire applicants based on a positive screening test for marijuana. So if you are an employer in Nevada and you do drug testing, you cannot refuse to hire somebody because they've tested positive for marijuana. Employees are also allowed to ask for a second test. Now, just know, because some of you out there are going to be like, well, what about safety sensitive, DOT, all of those things? If there's some other, law that would say you can't have marijuana in your system because you're a forklift driver or you're an over-the-road trucker or things like that, they're excluded from this protection. But your run-of-the-mill office employee that tests positive for marijuana, you're not going to be able to say, I'm not going to hire you because you tested positive. That's a big change. And one of the only states that has gone that far to protect applicants and employees that use marijuana. Effective 1/1/20 also, private employers that have 50 or more employees have to now provide employees with up to 40 hours of paid leave per year for any reason. There's some limited exceptions to that, but there's basically now this new paid leave law that is statewide and applies to employees with or employers with 50 or more. And so it's 40 hours of paid leave for anything. This is an expansion of paid sick leave because they aren't just able to use it for paid sick leave. This is to be able to be used for just about everything. So if you're a Nevada employer and you have a call center, again, some of these are pretty limited in application, but if you have a call center, there's some new requirements about notice that you have to give if you're going to be doing a reduction in force. And that reduction in force has to be specifically because you're moving your call center to a foreign country. So interesting new law in Nevada. As of 1/1/20, also there is the Nevada Equal Rights Commission has the ability to give more, to award more penalties to an employee who suffers discrimination or some, other types of discrimination claims. So they're going to be able to award back pay for up to 2 years, order payment of lost wages, and then order civil penalties. So employers that have found themselves on the wrong side of the Nevada Equal Rights Commission now may have to face some additional penalties there as well. Also, the change to work comp law, which is interesting because work comp doesn't really change that often, but Nevada has amended its existing work comp law to require that an injured employee have the right to select their own physician. And so insurers have to provide at least 12 doctors from which they can choose, but many states you can't even require that. In a lot of states, you can never tell an employee which physician they have to go to. Some states, like Iowa, for example, you can tell the employee where they should go to receive care. Now in Nevada, an injured employee will have to have the right to choose their own treating physician should they have a work comp injury. New Hampshire, we've got none. New Jersey, no surprise here. Like I said, Nevada's the New Jersey of the West. Now we get to New Jersey, which is the New Jersey of the New Jersey. Starting 1/1/20, employers may not screen job applicants based on their prior salary history. So again, this is one of those trends that kind of keeps expanding, but you are no longer, if you're in New Jersey, you're not going to be able to ask employees and applicants about their prior salary history. The thinking here is, if somebody's been exposed to discrimination in pay in the past, well, their pay is just naturally going to be lower than it should be. So if you use their past pay to set their current salary, it's going to be low because they've been historically paid low. So now you are not going to be able to inquire about and use an applicant's prior salary history in setting what the history will be. You also, because here's one of the tricks that us lawyers say, well, ask the applicant for, a salary. What do they want to see? Do they want it to be between $50,000 and $55,000? You now cannot require that the applicant's salary history meet either a minimum or maximum threshold. So what I would say to you New Jersey employers is know what you're going to offer for a particular position and offer that. You really can't be using that salary history to make current salary decisions. The minimum wage is going up to $11 per hour. There's also the New Jersey Family Leave Act. So this is now going to apply to employers that have at least 30 employees. So it used to be 50. But employees can now take leave to become a foster parent. It expands the definition of who is going to be a family member. So just an expansion of the New Jersey Family Leave Act. Here's a question. So this is a great question. Can an employee not bring their salary up to try to get a better wage? So this is a question about salary history. If an applicant or an employee, you know what the employee's salary is, but if an applicant brings up, their salary on their own in an effort to negotiate a better salary, that's absolutely fine. You just can't compel that information. You can't try to find that out. But if somebody brings it up on their own, that's perfectly fine. Great question, though. Okay, New Mexico is got a couple here. Minimum wage increase. Again, it's different for non-tipped versus tipped employees. Again, there's also a new expungement act. So 1/1/20, employers can no longer ask applicants about criminal records that have been sealed or expunged in the past. Many, many, many states already have that law prohibiting employers from finding out about previous expungements, but New Mexico, as of 1/1/20, now has that as well. All right, not to be outdone by its neighbor to the south, we've got New York here. All right, so this minimum wage provision here is a mess. As I typed it, I just thought this is just confusing, but again, this is why we're providing the materials to you so that you don't have to fast and furious write out all of these notes here. But statewide minimum wage increased to $11.80 per hour. New York City, minimum wage of $15 per hour applies to all employers, whether large or small. Nassau, Suffolk, and Westchester counties, minimum wage went up to $13 per hour. And then employees of fast food establishments working for a chain with 30 or more establishments, so think Taco Bell, McDonald's, the big ones, the minimum wage is $15 per hour in New York City and $13.75 per hour outside of New York. So just so you know, there's some interesting little details there to keep in mind if you are in New York. There's also, so as of, this is December 31st, the salary threshold. So this is for employers that are wanting to use the administrative or executive exemptions to classify employees as exempt from minimum wage and overtime laws. New York has increased that salary threshold to $11.25 per week. In New York City, $9.75 in Westchester, and Long Island, and then $8.85 in the rest of the state. That's higher than even what the new federal law is going to be. The new federal law has raised the salary threshold for exempt employees, but New York and these other cities have gone above and beyond that and said that if you want somebody to be considered exempt under these laws, you're going to need to pay them more than even what the federal law requires. So there's lots more that goes into that as well. Again, could be a whole presentation on its own, but know that in New York, the salary threshold has gone up. As of January 6th, employers throughout the entire state are also prohibited from requesting salary history, so another salary history ban. There have been a lot of changes to the New York State human rights law. So for example, non-disclosure agreements that are entered into as part of employment contracts have to include a new carve-out allowing employees to talk to law enforcement, talk to the EEOC or the Division of Human Rights about illegal things the employer is doing, discrimination, that sort of thing. So you can have a non-disclosure agreement, that's fine, but after 1/1/20, there has to be an explicit exception for an employee to be able to talk about, to law enforcement and those sorts of things. Again, if you're a client and you have an NDA and you want us to help you draft up that language, we are happy to do it. The definition of employer expanded from New York employers with 4 or more employees to include employers of any size. This is happening as of February 8th. So again, this is just expanding the number of employers that the New York State human rights law is going to cover. So prohibiting discrimination on the basis of all of those protected classes, that's now going to apply to any employer in New York. There's also a paid family leave law that's got some interesting percentages there, but as of January 1st, 2020, employees that take leave under the New York paid family leave law will get 60% of their average weekly wage. There's a lot more that goes into that I don't have time to touch on, but just know that that is effective as of January 1st. And then any agricultural employer in New York, regardless of size, has to be covered by unemployment. So that's a new law there as well. North Carolina has none. North Dakota has none. How are we doing on time here? 12 minutes, so we're getting there. Ohio has some minimum wage increases as well, so $8.70 for large employers, $7.25 for small, so they consider that anybody grossing less than $319,000 annually, and then $4.35 for tipped workers. Cincinnati, getting into the city new law game here, they're barring employers again also from inquiring about salary history. That goes into effect mid-March of 2020. All right. Another trend that we keep seeing is changes to this independent contractor status. So really, I think the states are taking the lead from the feds a lot. It's very, very difficult to properly classify employees as independent contractors. And so where some states are really limiting that, other states are codifying this IRS 20-factor test. I think Tennessee did the same for this year as well. That 20-factor test is all about who has the ability to control the employee. Are you setting work schedules? How are you paying them? Are you paying them on your payroll? Or are you paying them per project? So they're taking that IRS 20-factor test and they are codifying that. So now if you're in Oklahoma, that is the test that you will use to determine whether an employee or a worker is an employee or an independent contractor. So that's the only thing we've got here in Oklahoma. Several things in Oregon here as well. So Oregon, effective January 1st, they've got a really interesting way of doing this. So it depends on what county you are in Oregon as to what minimum wage you have to follow. There are such a thing as standard and non-urban counties. There is a map out there for those of you that are in Oregon wondering who the heck are standard and who are considered non-urban. If you're in the Portland metro, it's 1325. So again, there's this Oregon Saves program now, and it's from way back in 2015, but it's essentially a retirement savings plan. It's state-sponsored that applies to employers that didn't otherwise have retirement plans that they were offering. So this went into effect back in 2015, and what is happening now is January 1st, 2020. So if you do not comply with the Oregon Saves law by 1/1/20, you're going to start facing penalties, because if you have been found not to comply in the past, you weren't getting any penalties applied to you, but now these penalties are going to start kicking in. If you're sitting there wondering, what is this? I've never heard of it and I need help, let us know. It would be happy to help you determine whether you have to comply with this or not. Effective 1/1/20, Oregon employers that have 6 or more employees have to provide accommodations to employees related to pregnancy. So if you have an employee that needs some type of accommodation, more breaks, days off, bed rest, things like that, if you have 6 or more employees, you have to provide accommodations to employees that are pregnant unless you can show undue hardship. Again, those undue hardship, proving that can be very difficult. Lactation accommodations, similar to one of the other states we already talked about, have been expanded and applies to employers of all sizes. Non-compete agreements, these are falling by the wayside anyway, so if you're still a company that uses non-competes for all of your employees, this isn't the only place where this is changing for the first quarter here, but be aware that there was a new law passed in 2019, so if you provide non-compete agreements within 30 days after the date of termination, you have to provide that signed copy. So it's not a huge change, but again, this is a new change here that you have to provide that copy within 30 days of termination. There's a new equal pay law. It was amended to add exemptions for collective bargaining agreements. So there's a couple of modifications there. And then there was a garnishment. So if you're an employer in Oregon and you are supposed to garnish wages for your employee, there is a modification to the amount of disposable earnings that you're required to let the employee keep. So that's going from $218 per week to $254. So make sure that you're leaving your employees facing garnishment with more wages after 1/1/20. Pennsylvania, so they have increased the state white-collar exempt salary threshold. This, again, is higher than what the feds have done that was effective January 1st. So they're joining the other states and have said, we're going to require that if you want to use a white-collar exemption to say that your employees are exempt, you need to raise that level of pay, again, over and above what that new federal rule is. It says it matches, but I think, and maybe I'm wrong, but I think it's a little high. I thought it was 33. I'll clarify that point and put it in the Q&A. Rhode Island, so non-exempt low-income employees in Rhode Island are not able to be given non-compete agreements anymore. So you'll only be able to provide those to exempt higher earning employees. South Carolina has none. South Dakota, effective minimum wage went up to $9.30 per hour. Again, this one here is only a change for non-tipped employees. So tipped employees does not increase there. Tennessee has a cell phone ban. So now as of 1/1/20, and if you're in Tennessee and you're like, I've never heard this, surprise, don't use your phone, don't hold your phone in your hand. You can use a hands-free device, but it really make sure that if you do have employees driving for you, that you update your policy to let them know that they should be using hands-free. And Tennessee, like Oklahoma, codified that IRS 20 factor test. So if, again, you're in Tennessee, you're trying to figure out whether a worker is an employee or an independent contractor, you now can use that IRS 20 factor test to figure that out. Texas, not very much here. There is a new data breach law that basically says if you're, as an employer, if you become aware of a data breach, you have to provide notice within 60 days to anybody whose personal information was acquired by an unauthorized person. So, excuse me. So there's just a new data breach law there in Texas. Utah, so this is another modification to a non-compete, but very limited application. This only applies to broadcasting employees, so it just changes the requirements for enforceability of non-competes for broadcasting employees. Vermont's minimum wage going up to $10.96, a nice round number. I don't know how they come up with these, but $10.96. Virginia, starting 1/1/20, employers have to provide both exempt and non-exempt employees with a written statement that lists the name and address of the employer, the number of hours worked in the pay period, rate of pay, gross wages, and the amount and purpose of any deduction. So this is a new record-keeping requirement for Virginia that employers are going to have to comply with. All right, we're getting to the W's. We're getting on the home stretch here. So I promise I'll get us out of here in time. Washington, as of 1/1/20, minimum wage went up $16.39 in Seattle for large employers, small employers. So it's going to depend on whether you pay toward medical benefits or tips. So it depends there. SeaTac, Tacoma have their own minimum wages. Washington getting in on this hate of non-compete agreements. So any non-compete agreement that's entered into against an employee that makes less than $100,000 per year is going to be void. So, and you are only going to be able to enforce non-competes against employees that make $100,000 more or more per year. So there's a new change there. Sexual harassment training. So this is for employers that have hotels or motels with 60 or more rooms. So you have to provide sexual harassment training if you are in the hotel industry with a hotel of that size. Paid family leave, it's been in effect since 2017, but as of 1/1/20, employees are now able to access the benefits under this law. So if for those of you that are not familiar, eligible employees are going to be able to get up to 12 weeks of paid family leave or medical leave per year. So just know that now employees are able to use that paid leave benefit. There is a Seattle employee commuter benefit that went into effect. So this only impacts Seattle-based employees. So I won't get into details, but it is there if you are in Seattle. West Virginia has none, Wisconsin has none, Wyoming has none, and that's the end. So let's see, how did I do? 2 minutes left. So that was a lot of talking for me. I'm going to have no voice for the rest of the day, but that wraps up the content that I have for you guys. Like I said at the beginning, you will get an email with a recording, with a PDF of the slides, the HRCI credit. All of that stuff will come out to you in the next couple of days, so sit tight. If you don't see it right away, don't worry. We always do send the follow-up. check your spam folder. Sometimes the emails do go there too. So thank you so much for joining us. I really hope this was helpful. If you loved it, let me know. If you hated it, also please let me know that too. And look for us next month on the next topic. So thank you so much to everybody for attending. I hope you found it helpful. Have a great day.